your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read. I'm not sure, but I honestly think.
Right from the very start, the judge drops a bombshell by saying this is the worst criminal record he's ever seen. That sets the tone for the entire hearing, serious, intense, and no nonsense. When a judge opens with a statement like that, it usually means things are about to get tough. What do you think should someone with this many convictions even get another chance?
That you have the worst criminal history I've seen.
I even said that to Mr. Rojas. I said this.
You have 19 misdemeanor convictions. You have 20 others that were either filed, dismissed because of pleas on the other cases. So technically about 39 misdemeanors. 21 felony convictions. That number is staggering. This isn't just a person with a troubled past. It's a lifetime pattern of crime. Felony convictions carry lifelong consequences, including loss of rights, strict sentencing, and almost no room for probation. The prosecutor knows this, and it's why they're pushing for the harshest outcome. Felony convictions. Good morning. Are you Matthew Wadsworth?
Yes.
And Mr. Wadsworth was previously in court and entered a plea of guilty to the second-degree felony offense of aggravated assault with a deadly weapon. There was an agreement for a cap of 8 years in prison. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
We have, Your Honor.
Yes, sir.
Are there any additions or corrections?
No, Your Honor.
Not from this one.
All right, Mr. Rojas, you may proceed.
Yeah, Judge, the cap of 8, the agreement, I think, is a cap of 8, and just based on the criminal history alone and the PSI, it looks like
It looks like you did a very good job of getting that agreement.
that's kind of what, not that I did a good job, but I think that may be doing a favor to Mr. Wadsworth. However, Judge, there are some things I'd like to point out. If you look at, and I'm talking about his felony criminal history, the first page of his, I guess, rolling into the second page of his felony criminal history, most of those offenses happened in 2002. So he seems to be getting those in bunches. Those happened in 2002. He got sentenced in 2000. All one. In January of 2002, they all happened.
Right.
Got revoked in 2003 on all of them. I think he did 60 months on all of them. Got some more in October 2002. Then after that, he goes and basically he's in and out until about 2019 when he picks up some more cases. And from 2019 to this present case, he's...
From after the 2002 and to the 2019, there were seven additional felonies.
Yes.
7 additional felonies.
Yeah.
Go ahead.
And then from 2019 to now, at least, he's able to stay clean. So he tells me that most of the time when he's committing offenses is when he's off his medications. He's been back on the meds and out in jail. It's helping him. He's able to think clearly now. We talked about this, and if the court's even going to consider probation, as pointed out in the PSI, the only way he's going to get probation is with safety to get help with his drug issues. He understands that. He recognizes that. He's willing to do that. He's hoping that you give him a chance to do that. And even as he pointed out by the probation officer in the report, he's indicated that he's tired of this lifestyle. He's tired of being in handcuffs. He realizes he needs help just to make his life better. And he tells me he's ready to make that change. And he does have some statements to make to you at the appropriate time.
All right, go ahead, sir.
I only wrote this because I get...
Despite the heavy record, the defendant tries to humanize himself, reading a letter about his struggles with medication, childhood trauma, and addiction. This is where it gets emotional. You can hear the sincerity, but the tough question remains. How much should personal struggles and addiction weigh against public safety when deciding someone's future?
really nervous.
Sure.
So I said, this letter is to ask you for some help. I'm a drug addict. I can... Oh, no. Basically, listen, man. I was a bad kid until I was ADD poster child. I was put on red alone. Then I did really good. The Ritalin, I went from straight F's, farting in class, thinking it was funny, picking my nose and eating it, all that stuff. I thought it was, I just was bad. They put me on Ritalin, I went from straight F's to straight A's. I was sexually abused. My parents were drug addicts. I went to prison. You guys forgot something. I hope it don't hurt me, but I got to bring it up. I had a robbery in 1992. When I got out from that robbery until 2000,
Two.
when you started, 2002, yes ma'am. I stayed out of trouble again because I was on medication. It's been my whole life. It's been the pattern of my life. I'm on my medication. I'm a great guy. I'm a journeyman electrician. I'm a father. I'm a grandfather. I spend time with my kids. If I'm off of them, and the reason I got off of them and this offense happened is I was hearing voices. I thought my roommate was holding my girlfriend hostage. It says I hit him with a bat, but it was my walking cane. It wasn't a bat. And I did hit him, and I felt horrible because I found what was going on in my head. Our house burned down, dogs died, and I just kind of went crazy. But I did stop. I did tell in 2018. 19. I said I'm tired of this, and I'm gonna stay on my medications. When the house burned down, all my medications went with it. My truck, my tools, and everything. And I was just barely making it. And I honestly thought my roommate was holding my girlfriend against her will and hostage. And we started fighting, I was losing. And I said, if you do give me the chance, what I need is some help staying on my meds. Because I start feeling like I'm doing better sometimes. And then I stopped taking them. When I stopped taking them, I hear voices, and I can't tell if it's mine or if it's somebody else, or I can't tell.
So, but Mr. Wadsworth, here's the thing.
Yes, ma'am.
And I appreciate what you're saying, and I feel like you are sincere in what you're saying. The problem is you're 51 now, 52?
51.
51.
Fixing to be 52.
And you've had these issues.
Yes, ma'am.
You've been given opportunities. And I need...
The judge keeps circling back to one key point: personal responsibility. Courts can offer probation, counseling, or treatment. But at the end of the day, nobody can force someone to take their meds or stay out of trouble forever. The judge's frustration is clear, and it raises a tough debate. Is this too harsh or simply a realistic acknowledgement of his history?
to be on my meds. And even if I give you a probation, it's only for so long. At some point, you have to stay on your own meds, and you can't require someone else to force you to do that and take a chance with society and the community of you hurting someone else. Honestly, I'm not sure, but I honestly think that you have the worst criminal history I've seen.
I even said that to Mr. Rojas. I said this.
You have 19 misdemeanor convictions. You have 20 others that were either filed, dismissed because of pleas on the other cases. So technically about 39 misdemeanors. 21 felony convictions. 21. I know, wow, right?
I'm not.
You still have one pending in Indiana. And in addition to the 21 and the one pending, you have 16 others that were dismissed because of plea agreements, and things like that. So that's 38 felonies. The last, and I get a lot of this was from '02, and a lot of it was in the same big scenario.
19 of them was in one.
But it didn't stop then. You were put back on probation in 2017. So not that long ago, given a probation, it was revoked. So you were given an opportunity. Mr.
I
Mr.
completely
Smith,
stand-
When the defendant claims he has stayed out of trouble, the judge immediately calls him out by listing recent offenses from 2017 through 2019. That's a huge credibility hit. In court, honesty matters because the moment a defendant bends the truth, even slightly judges are far less likely to show leniency.
completely stayed out of trouble since then, though. Not one single incident.
well, you had 2017 an unauthorized use of a vehicle felony, 2018 an obstruction of justice in Pike County,
Yes, ma'am.
2019 an escape. That's the one that's pending. Hold on.
Oh, I'm sorry.
And then another later in 2019, maintaining a common nuisance of a controlled substance or something like that in Indiana. So the last thing is 2019, which is, in the big scheme of things at your age, not that long ago.
I know, I understand.
Mr. Smith?
Judge, I would point you to his account to probation where he said the part about the baseball bat is not true. A dresser fell on top of him.
I saw that.
He's still not protecting responsibility.
I hit him with the cane.
Hold on, don't
I'm
speak
sorry.
over. I let you talk, so don't talk over anyone else, please.
I believe probation is absolutely right that jail time and probation has not been a deterrent for him. He's not made probation. We would ask for the 8 years to DC.
Mr. Wadsworth, again, like I stated before, to Mr. Rojas, the fact that he was able to negotiate for you a cap of 8 years on a second-degree felony with your criminal history, there's part of me today that was considering not even accepting this plea agreement. Because I think with your criminal history, personally, I think it's ridiculous.
I have to understand.
So I'm going to find that you entered your plea of guilty freely and voluntarily. I'm going to find that you entered your plea of guilty. I'm going to find sufficient evidence to...
Finally, the judge hands down an 8-year prison sentence. Considering his extensive record, it could have been much worse. But here's the big takeaway. Plea deals can drastically reduce sentences even for habitual offenders. What do you think, was 8 years fair justice, or did he actually get lucky this time?
Find you guilty, and at this time find you guilty of aggravated assault with a deadly weapon. Sentence you to a term of 8 years in the institutional division of the Texas Department of Corrections. There will be an affirmative finding of a deadly weapon. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Rojas. There's help in prison for you with medication. It's going to be up to you when you get out to either change your life if you really want to or not, and you'll have to do that on your own. All right, good luck to you, sir. You can go back with the bailiff.